Welcome to Senior Stay or Go TV, a show to educate, entertain, and advocate on behalf of our aging adults. We are here to provide you the best information for your quality of life.
Hi, and welcome to Senior Stay or Go TV. Today we have two great guests. We have Charles Scott and Lori Bolander, who are both partners with Kimble Tyree and St. John here in San Diego. And we welcome you to Senior Stay or Go. Thanks for coming on.
Thanks for having us.
Thank you for joining us today. This is quite an honor to have you both here. I know you're very busy. And before we get into the questions, I want the audience to understand that this is a topic that is everybody needs to know, but it's the want to know and the action that they really need to understand. And for those that are viewing this, I mean, this is like having Tom Brady and Serena Williams in studio today. I mean, we have two legendary attorneys very young, but legendary attorneys here in San Diego that if you want to engage their services, they are the best of the best. So thank you for joining us today.
Thank you.
So we're going to get started in the topic of estate planning, which is this gigantic topic that we could spend days on, but we're going to try to condense it for everybody. Most folks hear about the word having a trust to avoid probate. Tell us a little bit about why they need a trust to avoid probate, and what is probate?
Yeah, so probate is something I think that everybody thinks that they know they don't want to do, but they don't know why. And really what probate is just the court proceeding that takes assets out of your name when you die. And if you have a will, it doesn't actually avoid the probate proceeding because the assets are all still in your name. The will be submitted to court, and the judge will follow what is in your will. They'll appoint that executor. They will distribute the estate pursuant to your will, but it doesn't actually avoid the procedure itself. Where a trust comes in is you actually fund your trust with your assets during your lifetime, and then when you die, there's no assets in your name. They're titled in your trust. Your trust then directs the successor trustee to step in and administer those. So then the court proceeding is avoided in that way.
And just to kind of probate, it's a public entity in the sense of...
Probate, when you file your will, it's usually a public document. You have to file the executor has to file a list of your assets, and it's a public proceeding.
And the time frames on probate can be...
Yeah, probate, I mean, these days with the judges being backed up as they are, it's probably at least a year. You can close the estate after 4 months usually when the creditor's claim period has expired. But generally you're still doing things and inventorying assets at that point in time. And then to get your final hearing, to get your petition for distribution heard, usually is being set out, I don't know, probably 3 to 6 months at this point. So even if you're ready to close the estate, you have to file your petition and then wait for your hearing.
And just the people that are going through probate, I want them to understand that people like Patty and I are going down to the courthouse to find out if you own real estate.
Right.
And then you're going to get about 300 real estate agents sending you letters about the real
exactly.
estate. So you get hounded.
Which is one of my examples of how you know that it's a public proceeding. Hello.
The other problem is California's probate system is really expensive, and it's really slow, and the trust avoids that whole system, which is why most people that think about it in advance, they do trusts.
And just before we go to the next one, that's a good point. This is California law, which is, and this is internet, so it can go all over the globe, obviously. So if you're listening to in Minnesota or Wisconsin?
Both.
Both.
Really.
You got to avoid, congratulations to Green Bay, by the way. You got to avoid, you have to understand it's different, right, in every state.
It's very different, and some states have very streamlined, modern probate systems, and in those states, people don't do trusts nearly as much. But in California, we're stuck with the law we have, and that's why people do trusts.
Yeah. And some of the states are antiquated, but they are very easy. So
California doesn't quite.
Yeah, California just, our probate code's pretty thick, and we've got a lot of rules and regulations and things that you have to go through in order to get through your probate.
Well, let's face it, what everybody's looking for is to pass their assets along to their loved ones in the quickest and least expensive way possible. And in California, that means a trust.
So there's obviously more reasons than just probate to do a trust,
Absolutely.
so that you can pass on your assets without any glitches and know that it's going where you chose for it to go.
Yeah, one of the big things with estate planning, we don't just do a trust, we'll do what's called a pour-over will, which makes sure that if there is anything outside of your trust, and it needs to be submitted to probate, that it goes over into your trust, and a power of attorney and a healthcare directive. So these are integral documents. And one of the big things with trusts and, probate is bad, but you're going to be gone. There's also a proceeding called a conservatorship that happens while you're alive, and in my experience can be more expensive, more arduous, more filled with conflict than a probate proceeding.
Yep.
And it's you're alive, so you may not have capacity, but people are having to deal with your assets and your physical care, because there's two types of conservatorships.
Yep, we had to do that for my mom, unfortunately. What about, with all the internet stuff and all the passwords and all the people on social media and trying to get into their accounts after they've passed away? Is that now part of your estate plan, is trying to figure out, can you please give us a list of passwords and what you're on? And so family members who maybe don't, for instance, my husband wouldn't know how to get on my Facebook page. He's not on Facebook. So
And is there a reason for that?
not really. It's just he has no desire. But for instance, I have a friend who passed away, and his kids can't get on his Facebook page, and every year his birthday still pops up, and it's kind of sad to even see that still popping up.
One of the things that you can do is in your power of attorney, which is the document, it's not a trust, but it's something that usually is used while you're alive, but you can also put language in there that allows your agent to get access to your digital assets, and most internet companies will honor that and work with you as long as you have some kind of document signed that says this person has the right to access your digital life.
Okay. How about banks? I know I have a friend who recently was the second signer on her dad's accounts, and after he passed away, the bank still wouldn't let her withdraw any funds from that account.
There's a lot of misconceptions about that. People come in and say, well, I'm on the bank account.
Right.
But when you are a signer on the bank account or a signer on a credit card or something like that, the law presumes that at death, that consent that the person gave you to be on their account is revoked. It's kind of like the power of attorney.
Okay.
The power of attorney doesn't work after death because you're basically stepping into their shoes, and if there's no shoes to step in, there's no power anymore. So it's kind of the same thing with signers on bank accounts. And sometimes that can be a problem because that's the access to the cash. And dealing with the trust usually we can get access pretty quickly, but if it's outside of the trust, then we may have to wait 40 days so that we can do a declaration under Probate Code 13100 to have access to the account, which is a declaration you can sign stating there's no probate and that there's no assets over $150,000 that would necessitate a probate. And then you can go in and get the money, but that can sometimes put a roadblock in things like final expenses and things of that nature.
Yeah.
Or if somebody doesn't have a trust, then it's got to go through the probate process, and nobody can get access until the judge appoints an executor, and that could take months.
Yeah.
Wow.
And then you end up in situations where I'm sure you guys have seen with real estate where the mortgage doesn't get paid and
taxes don't get paid.
Taxes don't get paid, and so then by the time we get somebody appointed, now we kind of have a mess. And a lot of times people don't run right down to our office and say, I need to do a probate. They may wait months and months until these problems start occurring and they realize that they can't do anything because nobody has any authority. So, there's a giant mess to clean up once we get the probate initiated. And again, why sometimes it takes a really long time to finalize these probates.
Sometimes there can be a foreclosure sale threatened, and there's no way to get access to it, and they won't even tell you who to deal with because of the confidentiality laws. The mortgage company won't deal with anyone until there's an official person appointed, and that's where it gets really sticky and very expensive again.
Yeah.
So, you've been doing this a few years. What do you think people wait, or are they just oblivious to it? They want to ignore it, or what's your experience in
That's
that?
a horrible thing to think about. You're talking about something that's worse than a trip to the doctor or the dentist. Yeah. Plus, there's it's easy to put off. It's just human nature not to want to think about it. It brings up family conflicts a lot of times, who you're going to choose to be the trustee or the executor, whether the child who has a drug problem or an alcohol problem is going to inherit or get disinherited or do something else. And people don't know that there's usually answers to these things, and there's ways to deal with them if you use a professional that knows what they're doing. But if you just ignore it, stick your head in the sand, you end up with a big mess.
And let's just talk a little bit about
funny you say
funding the trust. I mean, that word is out there. It always gets, what do you mean? It's like some like mysterious mystery.
Right.
What does funding the trust actually mean?
Trust is an empty bucket. You put things in it. Nothing falls into it automatically. It's a thing that says, here are my assets, here's my trustee, these assets that are in the trust, this trustee can do things with. And if you don't have assets in there, then you have to get them in there in some other way, which sometimes involves going back to court again, which is what you're trying to avoid. So part of the process when you're setting up a trust is to deed the house into the trust, transfer your stocks into the trust, deal with your bank accounts, and that's where people tend to get a little sloppy, because once they finish signing the papers, they figure they're done. Or they buy another house and they don't think about the fact that they don't want title in their name, they want it in the trust name. So if you don't put things in the trust, they're not in there.
Or they refinance and take it out of the trust to refinance and never put it back in the trust.
Yes.
Right.
We see that a lot.
Sometimes there's ways to finesse that, but in general it takes a court order, and again, you're sort of defeating the purpose.
Let's take the documents that we talked about. The trust itself is, and then there's the will, and then let's talk about healthcare directives, because that really, to me, I mean, we pretty much know we're all going to be incapacitated at some point in time through our lifetime, and that's really one that gets ignored, I think, way too often.
Yeah, absolutely. And it's important because of all the privacy laws regarding people's health care. You need to have this document appointing somebody that can make, so they can make decisions for you in the event that you can't. And then in a lot of our documents, we will also talk about, you know, whether you're going to be buried or cremated, obviously the life support issue, donation of organs and things of that nature. But that document can be extremely critical during your lifetime, and that's another one where people kind of think they know they're supposed to have one, or, oh, I did one with my doctor. The problem with doing one with your doctor is generally they're not giving you the state approved form, they're giving you the internal office one. And so if you go to Sharp, it works at Sharp, but if you get taken in an ambulance somewhere else, it's not going to work somewhere else. So, you know, setting up that healthcare directive is very important, and, you know, can literally be life or death in some situations.
And what do you suggest to people that have that binder and it's collecting dust someplace? How often should they review? Because life changes.
Yes.
No, it's
And I always say, you know, the life changes are probably going to be something that will prompt you to change your estate plan more than the law, because the law doesn't change that often in this area. It might change in, you know, some case law here and there on will contests or something like that. But the big major thing, which is a major change in 2001 with the healthcare privacy laws, and then of course we've had some big estate tax changes over the last however many years, which is a really good reason for people to look at their trust, actually, because of the type of trust that was being standard usage.
the AB trust.
The AB trust. You know, a lot of people don't need that anymore, and it can be very arduous after the first person's death. So taking a look at that. So there are some big things that will happen that will necessitate a change because of the law, but a lot of times it's, you know, the kids are older now. We don't need to hold things in trust for them, or we held them in trust till they were 35, but they're, you know, 25 and 27, and they're actually really responsible. So I think we can pull those provisions back or whatnot. So it's a lot of times it'll be things in life. Obviously, a death or a divorce or a birth are things that are gonna prompt a change in your estate plan.
You see people coming in terms of gifting more? Is that becoming more something they're involved with in terms of, because of the size of the estate tax, in terms of the limits and things like that?
It's actually less common now. It used to be there were a lot of people that were potentially going to have to pay estate taxes when they died because the limits were relatively low. And in those days, people would have to use a lawyer to do a gifting plan to try to get assets out of their estate before they die so they wouldn't have to pay tax on it. Now the exemption's $5.5 million per person, and frankly, that makes most people not have to worry about estate taxes. So now, if you want to make a gift, it's out of your affection or for practical reasons rather than for tax reasons usually.
That's good. That's good. So we've walked through the documents, we've walked through timing, we've talked about that. What about Proposition 13, and how does that affect the estate when someone passes? So people sometimes, you know, one of their spouses pass and they don't really realize that there's a little bit of homework that they should probably do for later on. What do you advise your clients when that occurs?
Prop 13 is an area that's hyper technical and has a lot of hidden traps in it. There are exemptions. Prop 13, just to be clear, that's local San Diego County property tax. Has nothing to do with the Internal Revenue Service, has nothing to do with death taxes or inheritance taxes. It's just how much property tax you pay every year. And most people that have owned their houses for a while have a low property tax under Prop 13, which was the idea. And there are exemptions for transfers to spouses and to children, so that if a child inherits a house, they don't get reassessed and they keep the low number for the property tax. But it has to be done in a very specific way. And one of the big traps is if you give something to a grandchild, that's not exempt under most circumstances. The other problems are that if you give a house to 3 children and 2 of them buy out the other child, 2/3 of it gets reassessed if you don't follow a very specific, very complicated procedure. So there's ways to do it, there's ways to preserve the tax breaks of Prop 13, but you've got to be very careful how you do it.
Okay.
Just one more thing, that because one of the things that Patty and I get involved with is, should I sell now or again wait till I pass away? Why is that conversation? What is that conversation about?
Well, I mean, I think that's multifaceted. There's sometimes cost of care, and you know, whether or not they want their children to keep the property. Sometimes a reverse mortgage is appropriate for them. So there's lots of different aspects that go into that decision. But we deal with it a lot because a lot of times we'll have children coming to us saying, "I'm caring for mom, she's in her home. You know, what do we do? Because we're running out of money and we don't know if we want to keep the house or put her in a home. She doesn't want to go to a home." So there's a lot of things that go into that.
But they're talking about the step up in basis.
Oh, the step up in basis.
Particularly.
Yeah, so if you wait till you die, then you can utilize, well, you can actually gift your house during lifetime to your child and keep that, but you don't get a step up in basis on the basis for capital gains purposes. So when you purchase a property in 1975 for $200,000 and it's now worth $1 million, if you gift the property to your child during your lifetime, then they're going to keep your 1975 basis of $200,000. So when they sell the property, they're going to pay a huge capital gain. So then they're going to be looking at a situation where they need to do a 1031 exchange or owe Uncle Sam a lot of money. So
And those people don't want to get involved with Uncle Sam.
yeah, and a lot of people don't realize that. And I know I'm it's an issue with A and B trusts too, because
Right.
the B trust keeps the date of death of the first spouse's basis, and so then you're looking at a big step up on those too.
Again, it gets into a very confusing area because most people get confused between the capital gains basis of the property, which has to do with the Internal Revenue Service and the federal government, and what we're talking about, the Prop 13, which is local property tax. They have nothing whatsoever to do with one another, but people get very confused on that concept because they're both taxes and they're both based on how long you've owned it.
And they're both waiting for you.
Generally, one of the biggest mistakes you can make from a tax point of view is gifting a house while you're alive to somebody if it's got a very, very low capital gains cost basis. If you wait and they inherit it, all that capital gains goes up in smoke and the tax is avoided. And unfortunately, once you do that deed to the child, you can't take it back, and you've triggered a lot of taxes that you didn't need to pay. So that's another reason why it's good to talk to a tax advisor or a lawyer about it before you do it.
Yeah, we see a lot of times where mom or dad will put one of their children on title, and it's like, ooh.
It's very common. It's to avoid probate, and it's a good intention, but it's a very expensive mistake.
Yep.
So
Yeah,
you
and it can end very badly for the parent, I've seen as well.
So don't go online and think you're going to get all your answers from some online website.
Right.
We have a very recognized law firm here in our studio, Kimble Tyree in St. John. Tell us a little bit more about the firm and some of the other areas that the other lawyers focus in on.
Yeah, so the firm has historically been a real estate firm and a landlord-tenant firm. And although Charles, you've been there for how many years?
Over 15 years now.
Yeah, over 15 years. And Charles, for many years, was the only person practicing trust and estates. But we've kind of developed a little team within the firm there now. We've got 4 attorneys and looking at bringing on another one, exclusively looking at trust and estates and practicing in that area.
It's a real need because there are all of these traps and people doing it themselves. And that brings up another point, Ron, what you're talking about, people going on their computers.
Yep.
I would say a significant portion of my practice now is fixing problems caused by people doing it themselves on their computers. It's very, very deceiving because you get a form, you think you know how to fill it out, you change a couple words here and there, the kids come in with it, and it turns out it's a complete hash.
Yeah, and I think, one of the major reasons people do this is to save money, and in the end, they end up costing
them
so
It's
much
it's
more
a very
money.
false economy.
Yeah.
Yeah.
It's such a necessary part of someone's planning. I mean, Patty, you had a client a couple of years. I mean, they had like 2 or 3 properties and kids, and we
And they
couldn't
still haven't done
drag them.
They still haven't done anything. It's
Yeah.
crazy.
You can lead the horse to water type of thing. So I'm
Right.
hoping that those that are viewing understand that you've got to get the information, so at least you can decide, make an intelligent decision as to what you're doing. And obviously, in terms of who you want your successor trustee to be, and really think that through. I think that's, obviously that's where the 4 of us get involved many, many times. We have seen, I mean, we could share
Well, and know
stories.
that can change. It's not etched in stone. So
Right.
I think sometimes people say, well, I'll get to it when I really make that decision, but they don't understand that it can change over time.
Yeah, and even when I meet with my clients initially and we start talking about what their decisions are that's going to go into their drafts, I tell them, you can still make these decisions in this draft process. You can go home and change your mind and say, I didn't like how that was worded. That's fine. Or you can think about, who the guardians of your children are going to be. That's a whole nother, issue that trust can address as far as avoiding a guardianship proceeding for minor children. So, even when you get to your attorney's office, they can help you make these decisions. They can give you the pros and the cons of appointing your son as opposed to appointing a private fiduciary or whatever the case may be. So even during the drafting process, we're still making decisions a lot of the time.
And people need to think a little bit about who they're going to use. The default is usually the oldest child.
Yep.
But when you talk to people, maybe it turns out that oldest child doesn't get along at all with the other children, and one of the younger children is much more of a consensus builder within the family. And if you appoint that oldest child, you're just asking for trouble because it's going to fracture the family.
And that's really, again, in terms of family legacy, in terms of family harmony, I understand people go, well, they always say, well, I'll be gone. But that's, you don't want to leave that burden on your children. I mean, obviously we deal with private fiduciaries and we deal with bank fiduciaries to try to, bring those children into
Yeah.
line.
Well,
that's
and that's
an
who
option.
gets appointed when they start fighting too. So
And that's an option that everybody should think about. There are, in San Diego, we're lucky, we have a lot of good private trustees who are available to use if the family doesn't have a good person to be the trustee. People that don't have children, people that have children that fight, you can appoint a neutral person to be the trustee. It's going to cost a little bit, but it's way cheaper than litigation.
Yeah, and I don't know any children that don't fight. So.
well, that's what my clients always tell me. All my children get along great. Everything's going to be fine.
And then they lay money on the table. And
Yeah, and then I do this.
Well, we thank you both for being here today. Patty and I highly encourage, please give them, Lori or Charles, a call, email, and just have a conversation about their situation and hopefully straighten it out so they don't have chaos going down the road. So thank you both for being here today.
Thanks for having
you.
us.
Stay tuned for more Senior Stay or Go TV.